Welcome, everyone. I want to take a couple of minutes to welcome you. Now, I want to share my screen and we can start our presentation. So, again, my name is Dalia Anise. I am an estate planning attorney with Legacy Life Plan. Today, we're going to talk about Estate Planning 101. What is estate planning really about? We're going to talk about the different documents that you need to have, what happens, we're going to talk about incapacity planning and end of life situations, as well as what happens to my stuff after I'm gone. So, what is estate planning all about? These are the specific, we're going to talk about documents. These are the specific documents that you need to have in place, or most people need to have in place. Your will, okay? Now, I get a lot of calls like, I want to create a living will. A will, a last will and testament is very different from a living will. And I'll explain what a living will is. But we're talking about your last will and testament. This is the document that you say, after I pass, I want this to go to this person. These are my loved ones. These are my beneficiaries. I want to be cremated. So there's a whole lot of things that we can put in the will. But understand that a will is public record, okay? If you Google Jacqueline Onassis's will, you're going to see it and you're going to see all the details in her will, okay? It's crazy, right? You think a will is private matter, but a will, when it goes through probate, I'm going to explain what probate is in a little bit, is public record. And this will, once someone passes, it's deposited with the court, and then a probate case is opened on behalf of the deceased. A trust, on the other hand, is a little different. A trust it's like your treasure box. Okay. A trust is not public record. It works in a similar way like a will. Again, I'm going to get more into what a trust is a little bit later on, but it's a private vehicle where you can say who gets what, but it's not a public record. Like the will, when someone passes, they just submit in the court that they do have a trust, but it's completely private. And it's not, nobody sees what's in the will except the beneficiaries of the will. And it could work while you're alive, while you're incapacitated, and also after you pass away. Whereas a will takes effect only after you're passing. Okay, so a trust comes into play, and it takes care of your assets while you're alive, while you have capacity, while you're incapacitated, as well as after you pass away. And it also keeps taking care of your beneficiaries and your loved ones if you choose the trust to continue. Whereas a will just says, give this to so-and-so, and it gives them outright. And once the probate process is done, everything is divided and everybody gets everything right away. Next, I want to talk about your healthcare directives. So that's where the living will comes into place. A living will tells people what your end of life decisions are. So for example, if someone does not want to be left in a vegetative state, okay, on a feeding tube with no brain activity, they say, just let me go in peace, and I don't want to be resuscitated. The doctors have said there's no hope in this person. I don't want to just be artificially kept alive. Okay. Or it also works as, I want to be artificially kept alive. So this is a living will, just tells your loved ones and the hospitals and the doctors your wishes should you become incapacitated, and these decisions need to be made for you. Another document is the HIPAA document. So this document, just because you may be married, your loved ones cannot go to the hospital and ask for reports, your medical reports. You have to give them, you have to allow them to get these medical reports for you. So this is a very vibrant, it's a document that allows your loved ones to get oral information about you as well as written information about you. There's also a document called the pre-need guardianship document. And this is such an important document. Most attorneys do not do this because I like it because if for some reason somebody goes to court to get guardian over you, this is a preemptive strike. This is saying if I ever need guardianship in court, these are the people that I want to be my guardians. So it could be in this situation, and this happened where it was a second marriage. Husband, started getting dementia, and the wife was taking care of him. And then one of his children from a previous marriage went to court to get guardianship over him. Now, the judges court, they don't know who we are. They don't know the family dynamics. They don't know what we want. All they judge is the person that's standing in front of them. They could be a horrible person inside, but all they see is the outside and showing kindness and so forth. And that child was able to get guardianship over his dad, even though his dad was married, and it was a mess to go to court and try to get guardianship back on her, for her husband. He didn't have an estate plan. He didn't name anybody. He had nothing in place. So a good estate plan helps keep your family out of court and out of conflict. Another document is your healthcare surrogate. This is somebody who will speak on your behalf if you cannot make decisions for yourself. So this, I will tell you my own personal experience with this and how important it was for my dad. My dad in November got diagnosed with brain cancer, and he was, getting confused and so forth. And we didn't know why. Everyone said it's dementia. It was not. We hadn't tested it, and it was brain cancer. And when he was in the hospital, there was talk about the doctor saying we should do a procedure to get a biopsy from his brain, which means they have to open a big hole in his skull to get a biopsy. My dad is 90 years old. So we were going back, like, are we going to really put him through this with the family and so forth? So I told the nurse there, I'm his power of attorney, his healthcare power of attorney. Please, no procedure gets done without me approving this. And she said, well, he has capacity. At the time, my dad was very confused. But every time the nurse would come in, she would say, hello, Mr. Youssef, hello, how are you? And he's like, fine, thank you. And she was judging this as he has capacity. I mean, my dad at the time, he thought I was his sister. He forgot my name. He was not in a place to make any healthcare decisions for himself. And this woman who had no idea who we are is telling me that no. See, I'm getting all worked up about it because it was such a tough situation for me. And she was like, no, he can make his own healthcare decisions. So I whipped out my paper that I am his healthcare surrogate, showed her the signatures that I am immediately his healthcare surrogate. And at that moment, she could not, and I was very, very clear that if something happens without my knowledge, this is not going to be good for her or the hospital for that matter. The interesting thing is her next shift, I wanted to make sure the nurse after her knew it. And I went there and without me saying, it's like, yes, we know you're his healthcare surrogate. So it's so important for us to have someone to speak on our behalf, to take care of us at a moment when we cannot take care of ourselves. The last thing I want to talk about is the financial power of attorney. And this is so important, okay? It's not just there are different types of power of attorney, but this is a durable power of attorney. And the durable power of attorney is different than a regular power of attorney because a regular power of attorney, if I become incapacitated, it's void. It does not work anymore. But a durable power of attorney withstands incapacity. So if I become incapacitated and I name someone as my agent, if I, to take care of my finances after I become, if I'm incapacitated, this survives incapacity. Okay, so it's a very, very important document as well. All right, so let's get into what estate planning is really about. Okay, it is really an act of love for our family, for our family members. And I want to tell you a story regarding this where father passed away. He was a prominent doctor. He did not have an estate plan, and he had a daughter that was in college. So he was paying for her rent, for her books, for all of her expenses. And all of a sudden, he passed away. Now, when someone passes away, it doesn't matter if he's married or not, and he has assets in his name or her name only, his accounts got shut down. She had no access to any money whatsoever to pay for anything. What happened is her family got together and paid for everything for her. She borrowed money from credit cards. Some of her family members borrowed money from credit cards as well to help her out, even though her father was a doctor and he did have assets, but it took some time to, it took about 6 months for her to be able to access his assets and be able to pay everybody back and have money. So imagine this, losing you, okay, your family losing you all of a sudden, and now they have to worry about money and they can't grieve properly. It's, even though my dad was 90, it really was a very difficult time for me when he passed away in February. It took some time for me. I needed to grieve, but my mom is still with us. And I was, the way he had his estate plan done, we did not need to access money right away. Everything was so in place that it allowed us to grieve. And if your loved ones don't have access to money and now they're worried and now there's a lot of anxiety going on, it really is difficult to grieve. Okay. The next thing, it's about self-care. Okay. And we hear that word a lot. And we think of self-care, we go to the spa, we get a, we get a massage, things like that. But I want to tell you that having someone, okay, naming people to take care of you when you cannot take care of yourself is so important. And so there was this gentleman who started to get dementia, and he was in Florida, and his son lived in a different state. His son came to see him. He put him in a memory care facility, and then the dad really dementia was very heavy. So it was too late. There is a point of no return. It was too late for the father to create an estate plan. Once you have dementia and you have no idea what you're signing, that document is void. You cannot be signing a document that you have no clue what powers you're giving or what you're doing. So the son had to, the nursing home was asking about things. He needed to get into his dad's bank account and so forth. So he had to do a guardianship over his dad. He went to court. The judge agreed, yes, dad has dementia. He needs a guardian. But he told the son, you're not going to be his guardian. And it was a big blow for the son. The son had some credit, they check his credit report. They had to do a lot of background digging. They found that the son did he had a bankruptcy in his past. He also had some credit card debt. And he says, you know what? No, I'm going to put a court-appointed guardian for your father, which means that this court-appointed guardian has complete power over the dad's finances, what he eats, what he drinks, where he lives, everything. And the son was devastated. All of a sudden, he has no access to his dad. And this stranger, this complete stranger, is taking care of all his dad's needs. The first thing that this guardian did, a court-appointed guardian, they get paid a lot of money from the person that they have guardianship over. The first thing that he did is he took him out of this really nice memory care center and put him in a really bad one. And his reasoning to the court is like this gentleman doesn't have enough money to be in this facility. What he was doing, he wasn't reserving the money for this father. He was reserving money for himself because he knew that once the money is depleted, he may not be able to get paid as much and court intervention, and there's a whole lot of stuff. So this court-appointed guardian did not have the father's best interest. And shortly after the father died, it was just a very, very bad situation to be in. The other thing I want to talk about is control. Listen, I'm an attorney and I like to be in control. Just letting you know, control is very important to me, and it's very important to a lot of people because we worked hard for our money. We want to control who gets our money. Okay, it's only fair. And did you know that your assets can go to people you don't even know? And I'll tell you an interesting situation. So, grandfather owned a home and he said, I want to give my home to my oldest granddaughter, the oldest granddaughter in the family. Everybody was happy. Everybody loved her. Very tight-knit family. Everybody loved each other. No problems whatsoever. And then grandfather died. Granddaughter inherited his house. She was married. Everybody loved her husband. Okay. Beautiful family. And then all of a sudden, this granddaughter, she was married. She had no kids. But even if she had kids in this situation, it doesn't matter. Granddaughter died. Who inherited granddaughter? Her husband, of course, right? Married, her husband inherited her, and he also inherited the home. A few months later, everybody was grieving for granddaughter, but husband got remarried. And now who owns the house? People who are not even related to grandfather. Really difficult situation here. So the family went to that husband and they said, listen, grandpa loved you. You're a good person, but listen, this was not intended for the family home. We wanted our granddaughter, the great grandkids to be raised there. We did not intend for this to happen. Can you please give us the house back so that we can give it to somebody in the family? And he said, are you joking? They're like, no, we want the house back. He's like, no, I'm not giving it the house back. It's my house. And they tried to sue him. Of course, it did not work. All the attorneys refused the case. It's his house now. And this was not the intention of the family for the family assets to go to people that they did not even know. All right. So next, I want to talk to you about probate. We hear that word a lot, and we hear like, oh, probate, it's horrible. It's the worst thing in the world, Just give me a second. Yeah. So yes and no, right? It depends. It really depends. What is probate? Probate is really a lawsuit on your assets that tells creditors, hey there, so-and-so died. If you have any money that's owed, come and get it. This is really what the probate process does, okay? It also allows the will, if you have a will, to go through probate to be authenticated so that a judge can say, yes, let me see, the signatures are correct, the notary and the witnesses, yeah, looks like it's legitimate. And if somebody protests, then the judge will, then there's going to be another issue in court, right? But once the will is, the judge says it's authentic, we start the probate process. But what if somebody doesn't have a probate? It's called intestate. You die without a will, and it just goes to, we look for your descendants. If you have a will, we look to see who you named as beneficiaries in your will. Again, public record, it takes 3 to 6 months in court. Okay, 3 to 6 months. It's a lot of time. And it's the attorney fees. So anything in court is expensive. And the legislature knows that. So Florida came up with a law for probate attorneys on how much they can charge. And it's about 3% of your assets. You think 3% is not a lot? It's a whole lot of money. So let's calculate what that looks like. Okay. I just put in some numbers. And most people now, especially if they have a home, their assets are a lot more than $1 million. So family home, stocks and bonds, bank accounts, it's $30,000 attorney fees. That does not include court fees, okay? And it also doesn't include a lot of other things that are needed. So if you have a business, you need a business appraiser. What if the business is not worth anything? It doesn't matter. The judge's going to order what's the net worth of this business? It has to be probated, even though the business has to be wound down. Of course, if there's a business appraiser, there's a CPA involved because they got to do all the books. It has to be certified. There's a whole lot of other fees involved. Life insurance, maybe if there's, an attorney needs to get involved and there's issues with the life insurance, retirement accounts, if they weren't designated in the right way. So there's also other fees, but the attorney fees is a big chunk. Now, who pays for this, right? You're going to say, well, the deceased pays for this. Well, maybe not, okay? Because we said when someone passes, their assets are frozen. You can't, even if you have a spouse, and there are spouses that have joint accounts. Some of them do not. Some have their own accounts. How about a retirement account? It's only in one person's name. The spouse cannot access it. It does take some time. So who pays for the funeral expenses? Who pays for the food, for all these things? Who pays for the attorney when the accounts are frozen? So this is a statistics from 2024. 52% of loved ones use their own money. Okay. Where does it come from? 54% use their own money when a loved one has passed. Okay. That's a lot right there. 52% use credit cards. They go into debt. 15% they borrow money from banks if they can, or they take out a loan. 39% they take it from their investments. They have to, from a 401k or so forth. 30% borrowed money from friends and relatives, like the story I told you. When you lose a loved one, it's so devastating. Number one, you just lost someone you love. And now you have to put in that chunk of money for the attorneys, for the funeral arrangements, on all of that. That is a lot. That is trauma just by itself. Okay. So all these things that I talked to you about, these are things that, and we're going to talk about how do we avoid these things from happening. But a couple other things that I want to also share with you before we get into that. Now, some of you have grandkids, right? What if I want to leave something for my grandchild and this grandchild is a minor? Well, there are some scenarios to do that. If I leave something in my will for a grandchild, anything more than $15,000, even if their parents are alive, has to go through court. It does not matter, okay? Because what was happening is, the movie stars, the child movie stars, their parents were taking advantage of them and so forth. So there were a lot of laws that came up to protect children, rightly so. But anything above $15,000, your children have to monitor it. They're guardians. They have to go to court, and the court monitors the money until this child is 18. And then the child gets everything at 18. So I don't know about you. I have my children are grown. My oldest is 35 and they're 36 and 35 right now. But when they were 18, they were not adults. And I have seen money ruin kids when they get it outright at 18. Okay, I know a friend of mine, he was telling me about his brother-in-law. He was 21. He inherited $20,000 or $30,000, and he thought that was an amazing amount. Dropped out of college. Of course, at the time he had $30,000. He had so many best friends. He partied, he lost it all. And then all of a sudden, no money, no friends. He discovered he's all by himself and he lost 2 years of his life. By the time he went back to college again, he lost so much time. He had to go back to college because he had nothing and he had no money. So money ruins kids when they get it in the wrong time. Okay. Could that be fixed with the right type of estate plan? Of course it can. The last issue that I want to talk to you that could happen is money going to the state of Florida. Maybe some of you heard that. So the state of Florida has a department called the Florida Department of Unclaimed Property. It has right now $2.9 billion. That's a lot of money. Guess where did this money come from? Most of it came from people who passed, people who died, and their families had no clue they had assets at certain bank accounts. Okay, can you believe it? So how does that happen? I passed away yesterday. I had a bank account and nobody knew about the bank account. A year passed, right? Nobody, my loved ones did not go get the bank account to look and see if anything or whatever. They had no idea. And year 2 passed, year 3 passed, and the bank's like, let's check on bank accounts with no movement for a few years. And they discover this bank account that has money in it, and there's no movement for the last 3 years. So they check, okay, let's look at the last known address. They send a letter to the last known address. And of course, it's been 3 to 4 years. What happened to this address? The home got sold, and the new owners either they're going to say return to sender or just put it in the garbage. Most likely, it's going to go in the garbage, and the bank is not going to hear from anybody. So the bank says, okay, well, it's been such a long time, no movement. We're giving it to the Florida state. Okay, what a shame. What a shame that our loved ones would lose money to the Florida state. And the Florida state, what do they do with this money? They use it for education and so forth. And there was an article in the Sun Sentinel that said how hard it is. Somebody found money for their loved ones with the Florida state. It took, if it was a good amount of money and it took her a very long time, not easy to get your money out of the clutches of the state. So another thing we definitely want to avoid. All right, so I told you I'm going to talk to you about trusts and explain what they are, because we talked about probate, we talked about your will going into probate and the problems that could happen. What is a trust? So I want to make this no legal terms. I want to make this as easy as possible for you. Imagine you decide to go to the supermarket, right? And you say, I don't want a lot of things. I'm just going to grab a few things in my hand. I don't want a shopping cart. So you grab some eggs, you grab a glass bottle, you grab some, a jar of mayo, all these things, and you're carrying them. You're heading to the register to pay for them, and you slip and fall. What happens to all this stuff? It goes flying in the air, crashes to the ground. We have a big mess on our hand. Let's look at another scenario. You decide to go shopping, go to the supermarket, but you take a cart with you and you put all the same exact items inside the cart, and you're pushing the cart and you slip and fall. You're fallen, but all your stuff is inside the cart. It's protected. And that's what a fully funded living trust is. It keeps your assets protected and for you. Like some people's like, I created a trust. What happens? You're in full control of the trust when you have capacity. When you don't have capacity, the person you named your successor trustee now can take care of your assets for your benefit. Okay, for your spouse's benefit, for whoever you name, for their benefit. Okay, but most people, when they're incapacitated, they want to be the beneficiaries of their trust because they need the money. And then upon passing, it passes in a really heart-centered way to your loved ones. So you notice here, it's a fully funded living trust. What does fully funded mean? Because I review a lot of trusts. People come to me, it's like, I want you to review this trust for me. And then I ask, okay, Did you retitle your assets in the name of a trust? They're like, no. Is your home is in your name? Yes. Is your bank account in your name? Yes. Okay, your assets are going to go through probate. What do you mean? I have a trust. You have an empty trust. So in order for the trust to work for you, it has to be funded. Funding means you have to retitle your assets in the name of the trust. So the deed is we create a new deed, and you go to your banks and you retitle the assets in the name of the trust, brokerage accounts, investment accounts, and so forth. 401ks and retirement accounts, they work a little differently, but it also depends on the family dynamics and your and certain things that you want to do with the trust. So that's very individualized. But a fully funded trust would completely avoid probate. Okay. All right. So I already have an estate plan. Do I still, what else do I need? Because some people already have it. Well, number one, when was the plan done? I'll tell you a really funny story. I was a year ago, I was reviewing one of my friend's estate plans. She said, I have one. Can you, and I was sitting with her and I found my name in her estate plan. I'm like, what is this? She named me as a guardian for her kids and a successor trustee. I'm like, when were you going to tell me? Thank goodness her kids were in college at the time, and she created this estate plan 10 years ago. Okay. And so we were redoing her plan because her kids were in college now, and all the things that she had in her estate plan don't work for her anymore. Okay. So she needed to upgrade her estate plan. And I'll tell you about, one thing that I do what for my clients is upon naming all the people that they name in their estate plan, upon approval from them, I send an email to these people and tell them, hey, so and so created an estate plan and you're named in this plan. I'm not going to give you, I don't give out my clients' documents. They can give you whatever documents they want to. It's whatever they wish. But I'm just letting you know, if you discover that somebody became incapacitated or passed, let me know so that I can support you. So the family members, whoever you name in your estate plan, really need to know that you named them because, all these documents you have in your shelf, nobody knows about and no one knows who you named. Second thing, under which state law? Florida now, there's a lot of people moving here from different states. If you have an estate plan under another state's laws, it may not work for you, especially the power of attorney. The Florida power of attorney is extremely different from any power of attorney in in different states. It's other states have springing power attorneys. Florida does not allow springing power of attorneys. And so when you need it, the banks and the institutions may not accept it. So it's very, very important to update your estate plan according to Florida law. Was the plan updated with life changes? So example of life changes, marriage, divorce, separation. Imagine if you're separated from someone and you name that someone, your estranged spouse to be your healthcare surrogate. Do you want your estranged spouse to make healthcare decisions on your behalf if if you have a concussion now and you need surgery, you get into a car accident, and now they're making healthcare decisions on your behalf? That's horrible. Okay. If a family member is death, so if a spouse has passed and you did your estate plan together, it's a good idea to update your estate plan. Or what about if you named someone in your estate plan and now you have a dispute with them? You named someone as your healthcare surrogate or a um, a trustee, and now you had a dispute. A lot of people forgot. Like sometimes, like who did you name? They're like, I have no idea. I haven't seen these papers for 10 years. I'm like, you need to go back and see who you named to take care of you, because these people, what one person told, we discovered that everybody they named has already passed. Okay, so it's very important to keep your estate plan updated. A birth of a child, we definitely don't want a child to be forgotten. And some estate plans don't include afterborn children because, there's, um, you know, children that are, born from wedlock and so forth. So some families do not want to include afterborn children at all, and that new child could be completely missed in the estate plan. If you bought a new home, if you have a child that turned 18, so because that child already needs their own, especially incapacity planning. So these are just general things, but there's a whole lot of other things also that can come up that need to be up to update your estate plan. All right, so I want to explain to you the difference between traditional estate planning and life and legacy. I just noticed a typo right there. A life and legacy planning. Traditional estate planning, when I went into estate planning, and I said, I was mentored by this amazing estate planning attorney. She vowed to change estate planning because she worked at a New York huge estate planning firm and saw how traditional estate planning fails people. Okay. And this is what we're going to talk about: traditional document centered versus heart centered estate planning. Document centered is all about the documents. And this is the general thinking of individuals right now, that I get calls like, "Hi, I want you to create documents for me." Okay. Based on what? Based on what? Traditional estate planning, you go to an attorney and you say, I want to give everything to my spouse or everything to my kids after I die. And they say, great, let's put together the documents. Okay. That is not an advocate. That is a document drafter. An attorney, heart-centered planning, an advocate for your family needs to understand your family dynamics. What's going on with your family? Is anybody have any special needs from your family? Is this going on? They need to understand your family dynamics and base the documents on your family dynamics, not the other way around. Okay. Standard estate planning may or may not work for you depending on what's going on. Okay. Second thing, the relationship ends at the signing of the document. So I have a lot of people, like when I'm reviewing, it's like, when was the last time you talked to your attorney? Oh, I have no idea. We did the documents 10 years ago, 5 years ago. Have you heard from your attorney? No, I have no idea. I can't even find them. They have no idea what's going on with their attorney. Okay. Whereas with my clients, every 3 years, I do a complimentary meeting with them, say, hey, let's see if your plan still works for you. Anything new? What's going on? And they really appreciate this, me getting back to them, because a lot of them come, oh, I've been wanting to call you because this happened. Life happens and we're so busy. So that when this, that 3 year meeting, and I don't charge for it, is such an important meeting. Of course, I tell them if anything happens, I'm also in touch with them during, not just within 3 years. We're also, I'm in touch with them. I send them emails saying hello, what's going on. I send them information. We're always in touch with my clients, but that special meeting that 3 year meeting is such an important meeting. Next, assets are missed and end up with the government. So what I do for my clients is we create together an asset table with all their assets. It's a cool Excel sheet. I'm very proud of it because it calculates their net worth, certain tax ramifications, and so forth, where they put their assets on this table. It helps them who the beneficiaries are, what's going on, if there are beneficiaries, no. It helps them keep track of their assets, as well as so that nothing gets missed and winds up with the Florida state. Again, money, traditional estate planning, things are missed and it goes through probate, where I give guidance to my clients to retitle their assets in the name of the trust. We don't just create, the documents they sign, like, here you go, there's your binder, goodbye, have a wonderful life. No, we go through each type of assets. I give them instructions. This is what you need to do. These are the documents you take. This is what and if they have questions, they come back to me. And after they retitle their document, their assets in the name of the trust, we have a final meeting. I call it the binder delivery meeting, where they show me evidence. I need to see that they did this. I want to make sure that they're successful. And then assets get inherited by people they don't even know. Whereas heart-centered estate planning, if a client tells me something, I tell them the ramifications of their decisions. A lot of times when you go to the traditional estate planning, they just say, okay. And we think that's great because they're doing exactly what we want, but we have no idea the ramifications of this decision that we want, or this is what I want to do with my assets. Great, wonderful. Okay, let me tell you what the consequences of what you want. And you may be okay with it. And you was like, oh my goodness, I had no clue. No, I don't want that, right? All right, so I said a lot of things. Now, how do we get started? How do we change things? How do we do right for our loved ones and ourselves as well? Okay, and this is the goal of a heart-centered estate plan, keeping our families out of court and out of conflict. All right, so how do we do it? The first step is not just a regular consultation. It's a life and legacy planning session. This is time that we meet together virtually. We'll do this on Zoom. If for some reason Zoom is something that you do not want to have the life and legacy planning session, please let me know. Even if you book one, just say, in the notes, if you could please, no, I'd prefer this in person, and we'll work something out to meet in person. But these meetings I have virtually, and I allocate 2 hours of my time. Some people use the full 2 hours. Some people take about an hour and a half. It really depends on you, but I don't like to rush you because, again, this is a very emotional thing. You're going to be talking about like very emotional things. I want to give you space to talk and discuss. Okay. So it's what do we do during this meeting? We talk about your finances. We talk about what would happen, right? What would happen if you passed away yesterday? Who's going to make healthcare decisions with the estate plan that you have now? So if you already have an estate plan, we'll discuss what you chose. If you don't have an estate plan, Florida State has a plan for you. Okay. So people are like, oh, I don't have anything in place. Well, that's okay. Well, Florida has something in place for you, and we'll discuss that. I'll tell you exactly what the law says would happen if you became incapacitated yesterday, to your assets, the cost of it. What would happen if you passed away yesterday? What happens to the different types of accounts? What would happen to your loved ones? We discuss all that. And then you make decisions from a place of empowerment. I empower you to make the right decisions for your family and your loved ones. So you can come and say, you know what? I'm okay with that happening. That's okay. I don't want to change that. But listen, this is huge. I do not want this to happen. How do we change it? And that's the starting point. During this meeting also, I will tell you about the cost of the estate plan. Everything is flat fee. I don't like hourly because it stops people from coming to me. Imagine you're on the clock all the time. Oh, I don't want to talk to my attorney and tell her this because she's going to start charging me. That's horrible because now we have a messed up plan that doesn't work for you. So everything is flat fee, no surprises. You're going to know how much everything costs. And it's a lifetime relationship. I'm a personal family lawyer. So my clients come to me with a lot of other questions, not just estate planning. And I tell them, if I don't know the answer, I'm going to send you to someone who knows the answer. I'm going to help you find the answer. So it's not just a one and done relationship. This is a lifetime relationship as well. Okay. And you know for certainty that your loved ones are taken care of. I'm not just here for you. I'm also here to support your loved ones. if you become incapacitated or upon your passing. All right, so I want to give you something for being with me here. It's been some time. It's 49 minutes. And there's two gifts that I want to give you. This 2-hour meeting that I allocate, I do charge $750. But I will tell you right now, you are educated than I want to say 80% of people out there, because you attended this meeting, and I wanna reward you for it. So I will not charge for this meeting, this 2-hour meeting, with me. So there's not going to be charged for that. And I'm also going to give you a gift of $250 off of whatever estate plan. I have different levels, and you choose the level you want based on what you find value in, okay, of my service. But you will get $250 off of your estate plan. So I want to go into Q&A, and I'm also, I want to put in the chat the link to book this session with me. Give me 1 second. Let me grab that. Here it is, the link. I will also put my address and phone number for you as well. Let me put this in the chat. Okay, so this link, if you click on it, you can book the life and legacy planning session with me. So let's talk about questions. Do you work with people outside of my area? Yes, I am licensed in Florida and New Jersey, but I don't practice in New Jersey. I have created a plan to do the estate plan completely virtually. I want to say 25% of my practice is done completely virtually to individuals who are outside my area. I'm in Boca Raton, and so, but I practice all over Florida. So yes, you're in Tampa, not a problem at all. I also want to put my address and information. And then I want to go over the questions. Copy this. Okay. Also giving you time to post things in the question area. Okay, paste. This is my information. Okay. And also, I want to tell you that I will give you up to Friday for the two gifts. Okay. There is an end to it. It's not like, never. So until Friday, if you book a time with me, I will honor those gifts. So let me look at the chat and see, can you do a trust before you're divorced? No, I don't recommend it. I don't recommend it. While you are in the middle of divorce, there are certain things that you can do with your assets. Um, you know, that's my feeling. Some attorneys can say, yeah, let's do a trust for you, because you are you cannot be transferring assets to your trust while you're in the middle of a divorce with that situation. It could be frowned upon from the judge and so forth. So that's something I don't suggest. You can also talk to your family law attorney about that. Okay. Okay, so some questions. What other questions? Let me see. Any other question? Yeah, so are there, regarding the house, right? So there are ways to retitle the house without a trust, right? It's called an enhanced life estate deed that allows your home to go to your beneficiaries, but there could be some ramifications for that. So if you have two children and they have and grandchildren, it may cause an issue where upon one of your children passes, it may not go to their grandkids. It may just go, I mean, it's better to have a trust and retitle the home in the name of the trust. You're also giving it outright to them. Okay. You're also giving the home outright, not inside a trust where that situation that I told you that, with the granddaughter, that the house can be inherited eventually by people you don't know, but keeping it in trust makes things a little better. But you can. It's called enhanced life estate deed, and that can be done. Okay. You would like a copy of the recording? Yes, but give me a couple days. I need to make it look right. I'm not very tech savvy, so sometimes it takes me. So if you're patient with me, yes, I can give you a copy of the recording. What else in the chat? I'd email a question about the Ladybird deed. Okay, so we talked about that, advantages and disadvantages of a Ladybird deed. A Ladybird deed will avoid probate, but you also have to look at the beneficiaries. If a beneficiary passes, what happens to their share? If both pass, then it has to go through probate. Whereas if it's in a trust, it does stay in a trust, and if somebody passes, you can have successor beneficiaries. You really cannot do that in a Ladybird deed. Yes, you would like to a copy. Let me write your name down, Kelly Miller. The best way to get a copy of this would be to email me. If you email me, you will definitely get a copy of this. Another thing. Okay, so do you keep a will? Great question. Already established when a trust is established. So when you create a trust, you create something called a pour over will with it. Okay. Having your old will with a new trust can cause a lot of confusion. And so I create it's part of the estate planning package that I also create this pour over will. It's a simple type of will that just says, if I forgot, because remember, you're going to retitle your assets in the name of the trust. And you just say, if an asset was forgotten outside my trust, do a very simple probate. I don't want a big probate case. Just do something very simple and pour it into my trust. So that asset that's been forgotten or outside my trust becomes part of the trust as well. Larry, I hope I answered your question. Okay, if you title your home into a trust, do you have to pay closing costs and are you in danger of losing? No. Okay, you're not, you don't. This is your home. Okay, this is a revocable trust. So you have a right to retitle it and you keep your homestead as well. We write that on the deed that this is your homestead, you're keeping your homestead. I actually put specific language in my trusts that allows you to keep homestead, and this is homestead property. So there's no, you don't have to pay any closing costs or anything like that. I have my son as beneficiary on all my accounts. Does this go through probate? Okay, so Patricia, let me tell you about this. No, if you have beneficiaries, it doesn't go through probate. But I will tell you a probate case that I just finished handling where mom and dad, mom died first. They had a joint account. Dad, everything was okay because it was a joint account. And then father died. They only had one daughter. So it's very simple, very simple. They named her as beneficiary on their bank account. So the bank apparently was bought by another bank and and they dropped all beneficiary designations. The daughter had evidence, like she had paperwork. It's like, here it is. It says, I am beneficiary for this bank account. And they're like, yeah, sorry, it was dropped, right? Are you going to go sue a bank? No. We had to do probate, and there wasn't even a lot of money in the account. Unfortunately, like she went through it, it took about 3.5 or 4 months, and we had to go through probate, and they wouldn't give her any of the money. So beneficiary designation is not always amazing, especially on bank accounts. Also, banks do not do contingent beneficiaries. I want to explain contingent beneficiaries. You'll find if you have a 401k or an IRA or something, they'll say, okay, this is my beneficiary. You can also name somebody second tier. If your beneficiary passes, then the contingent beneficiary goes. Most banks do not. And some banks don't even, you're not even allowed to name a beneficiary. I know Citibank is one of them. For checking accounts, you can't, there's no beneficiary designation. Okay, copy. If you put your home in the trust, does it avoid? No, it does not. It does not void homestead. Okay, let me look at more questions. Oh, you guys are great. I love your questions. Trust, no, not clear whether I still need a will. Yes, so if you have a trust, you still need a will. Or this is how I do it. And what happens if you have a trust, and what happens if you have an asset that wasn't retitled in the name of the trust? Probate is going to be needed, and it's going to pass as if you're intestate. That means you have nothing. It's not going to pass according to what you have in your trust. It's going to pass according to the Florida law of who's beneficiaries and where. My homestead is in a irrevocable trust. The assets are in irrevocable. You will. Everybody, you still need a will. A will is very important. I'm surprised that I mean, I don't know who did the trust for you, but a pour over will is a good idea to have with a trust. Who else here in the chat? If you create a trust, yes, you need a will if you create a trust. I have another question. Okay, so this is someone they want to name their children on their bank accounts. So let me tell you this is very dangerous. Putting other people other than your spouse, right, on your bank accounts and other accounts makes them co-owners. I had someone call me, and she was on her dad's bank accounts. She was on his rental property. She was on all like the deeds, everything. And she called me and she said, I want you to remove me from from the deed. I said, okay. Why? There must be a reason. And she said, my husband had a car accident. He killed someone. It was my husband's fault. And now they're going after all my dad's assets. I said, I cannot. After the incident happens, if you start hiding your assets, it's fraud. You would get in trouble. I would get in trouble. And the judge is going to unwind everything that we do anyway. So not a good idea. If you just understand this, whoever you put on your bank account, their problem is going to be your problem, no matter what. Their lawsuit, their creditors are going to be your creditors. So please don't do that. There are simple ways to allow your loved ones to get access to your accounts without doing that with a good estate plan in place. Homestead. I think I answered all questions. If I missed a question, can you please put it in the chat again? I don't think I missed anything. Well, thank you so much. It's been a pleasure being with you here. All right. Have a wonderful rest of your day. Take care. Bye-bye.